This short video highlights the statutory framework for challenging land use decisions. Obviously, this is not going to be an exhaustive coverage of land use litigation. It's just to note a few key principles and a few critical citations to legal authority. So first, I'm going to highlight 3 important state code sections that are relevant to litigating land use cases. Then I'll explain the burden of proof and standard of review for challenges to legislative land use decisions. And then I'm going to talk about the standard for a challenger to establish legal standing, like if neighbors who were upset about a land use approval wanted to mount a challenge. And then lastly, I'll highlight the remedies available if the challenger is successful. All right, so these 3 statutes you must consult very carefully. There are traps for the unwary, and without getting into some of the cases where those traps have been set, I will just point you to the statutes and advise again that you must read them carefully. Some of the traps for the unwary that have arisen in the cases we're hoping may soon be addressed by legislative changes, but you still will always need to look at these statutes. So 15.2-2311 involves appeals to the Board of Zoning Appeals. So for example, say the challenge is to a zoning administrator's determination that your client violated the zoning ordinance. 15.2-2314 is the appeal from that, so from the BZA to the circuit court. And then 15.2-2285F is an appeal to the circuit court contesting a decision of the governing body. So going back to part 1 with the land use approvals that we talked about, if it had ended in such a way that the applicant lost and didn't get the votes that they needed from the Board of Supervisors, and they felt that there was a reason to mount a challenge, this is the statute that you would rely on. So just a few key pointers about these. Again, very important to read the statutes, but for 15.2-2311, it's a 30-day appeal period. And note too that if it is a notice of violation that your client gets from the zoning administrator, it must contain notice of the appeal right and certain statutory language. In 15.2-2314, remember again, that's to appeal from the BZA to the circuit court. Again, it's 30 days after the final decision of the BZA. And here's one of those traps. It is not styled like plaintiff versus defendant. The statute says you must style this as in re, and then you put in the date, decision of the Board of Zoning Appeals of, and you insert the locality name. There is a mandatory writ of certiorari from the circuit court, and so the landowner, the applicant who was before the BZA, and the governing body are necessary parties to the proceedings in the circuit court. In 15.2-2285, an appeal to the circuit court from a legislative action, again, it's 30 days, and this will typically be a declaratory judgment action. On to the burden of proof and standard of review when you're challenging the legislative actions. So the burden of proof, the landowner, or the applicant, has to first produce evidence that the denial of its request for the legislative approval was arbitrary, capricious, or unreasonable. And then the burden shifts to the locality to respond with evidence that its decision was in fact reasonable. And then, if in light of all that evidence, the reasonableness of the locality's decision can be said to be fairly debatable, that's the standard, then the locality prevails. So this fairly debatable standard is obviously very beneficial to localities. The local legislative decisions enjoy this presumption of legislative validity. They're going to be judged under this fairly debatable standard. And what that means, as that standard has been articulated by the Virginia Supreme Court, it really means that nearly every legislative action is going to be allowed to stand. The court has articulated it to say the relevant inquiry is whether there was any evidence in the record sufficiently probative to make fairly debatable the issue of the decision to deny the applicant's request. They've also said to look at it as whether the evidence quote, would lead objective and reasonable persons to reach different conclusions. So what is the upshot of the fairly debatable standard? Well, as my friend John Foote says, the locality wins if it produces any credible and probative evidence, but fails only when it produces none. So what strategies can you employ if you're looking to mount a challenge? Well, first, the reality is that there's really been very few successful arbitrary and capricious challenges after the 1970s, other than a couple of outliers where the locality really produced no evidence. But some strategies involve really looking more for procedural defects, like notice breaches or failure to follow the ordinance or defects in the public hearing process. Of course, if you have proof of unlawful discrimination, that's a basis on which to challenge, but that's difficult to prove. All right, now say you are the lawyer for the neighbors who want to challenge the decision, and they're unhappy with something perhaps that the governing body just approved. Do they have standing? Well, that question is answered in Virginia by a case known as Friends of the Rappahannock versus Caroline County and its progeny. Friends held that a party with no ownership interest in the property has standing if it can satisfy a two-step test. So step one is that the complainant has to own or occupy real property within or in close proximity to the property that is the subject of the land use determination. And in that way, they establish they have a direct, immediate, pecuniary, and substantial interest in the decision. And second, the complainant must allege facts showing a particularized harm to some personal or property right, or the imposition of a burden or obligation upon them that's different from that suffered by the public generally. They do not need to establish that the particularized harm has already occurred. And it is worth noting that a number of recent Virginia Supreme Court cases suggest a shift from some of these more stringent application of the Friends case. So it's looking like the court has a slightly more expansive view of standing. So finally, looking at remedies. Unlike disputes between private parties, when you're challenging a local legislative action, the remedy may seem a bit unsatisfying. It's what we call the do-over. The court will order the governing body to reconsider in light of the opinion. It might specify the time in which the governing body needs to act, and that, of course, can be beneficial relief for a litigant. But ultimately, the court has no authority to rezone. Now, there is a statute in Virginia that is a damages remedy, but it's for a very particularized type of matter. And it's where there's been an excessive demand known as an unconstitutional condition. And that statute is 15.2, 2208.1, and provides that the grant or denial by a locality of any approval or permit, and I'm condensing a little here, but where it was based on an unconstitutional condition pursuant to either the federal or state constitution, shall be entitled to an award of compensatory damages and to an order remanding the matter to the locality with a direction to grant or issue the permits without the unconstitutional condition. And you also might be able to get reasonable attorney's fees and costs here. So this is the kind of thing that could be used where the locality tries to obtain an exaction from a developer that doesn't really bear a reasonable relationship to the impacts of the proposed development. That concludes the segment on the basics of challenging land use decisions. Again, not exhaustive, but please join me now with John Foote and Ben Lay in the next video segment, where, drawing upon the basics that I presented to you in part 1 about legislative land use approvals and part 2 about challenges to decisions, we will engage in a lively conversation about what it means to be a land use lawyer.